You're in the middle of your medical malpractice trial here in New York, and every time your attorney tries to ask a question or tries to introduce evidence, the defense attorney jumps up out of his seat, yells out, "Objection, Judge!" It seems like the defense attorney is intentionally obstructing your lawyer. And you're frustrated, and you want to know, what's this all about? How can he do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now, you're sitting in the back of the courtroom. This is your lawsuit. You brought a lawsuit against your doctor claiming that he was careless, and his carelessness caused you all this terrible harm and injury. And now it's taken you 2 years to get to trial. Now you're at trial, and your attorney is trying to ask questions of the witness on the witness stand. Every time he does that, the defense attorney jumps up, yells out, "Objection, Judge!" And he gives the judge some legal reason why he's objecting to the question. It seems as if the defense attorney is trying to prevent your lawyer from asking any questions. He's trying to prevent your lawyer from introducing any evidence. "Your Honor, I offer this document into evidence." "Objection, Judge, he can't do that." And now he continues, the defense lawyer continues to raise one objection after the next, after the next. After a little while, it looks like the defense attorney is a yo-yo. He keeps jumping up and down from his seat like a real yo-yo. And you're wondering, how can he do this? This is so frustrating. The momentum is stopped every few moments because the defense lawyer is interrupting your lawyer. And now the judge has to deal with the objection, and they have to hear argument about the objection. So now nothing is going smoothly. 5 minutes don't even go by without 3, 4, 5 different objections. And you're wondering, how can the jury sit and listen to this? How can they decide who's more likely right than wrong? The reality is that each attorney has an opportunity to object to any questions. They have an opportunity to object to evidence being introduced. And I will tell you something. At the end of the case, if the losing party decides to appeal the case, and now they take it up to the appellate division, that's the next highest court, the appellate division looks at the transcript of everything that went on during the course of the trial. And now if the attorney who lost the case says to the appellate court, "Listen, the judge made an incorrect legal ruling here," if the attorney did not object to that question or to the evidence coming in or to something else, the appellate court is going to turn around and say, "Hey, attorney, you waived your right to bring an appeal now. You had your chance to raise that objection. You didn't raise the objection, and because of that, you can't appeal that issue now." So the court will say basically, "Listen, have a nice time. The verdict is going to stand because you waived your right to appeal." But does that mean that the attorney has to object to every single question? The answer is no. Does that mean that the attorney has to object to every piece of evidence? No. Does he have to object to every witness who is called to testify? No. You want to know what we call that type of attorney? An obstructionist. Someone who is trying to obstruct the proceedings. And guess what? The jury will understand it very, very quickly. They will get the sense that the defense lawyer is trying to hide something. He doesn't want information to come out. He doesn't want them to hear certain evidence or testimony. So it becomes very obvious very quickly if the attorney keeps jumping up and down yelling, "Objection, objection, objection," over and over again, the jury gets the sense that, hey, what is so bad, what is so damaging that the attorney doesn't want this information to come out? So I know it's frustrating sitting in the back of the courtroom as the litigant watching this go on. And you will find, by the way, that the best lawyers in New York, either for the plaintiff, the injured patient, or representing the doctor or the hospital, the best ones are very selective about what it is that they object to. And it's a judgment call based upon the attorney's intuition, based upon what he knows to be right and wrong, to get up and make that objection. There have been times where I have been on trial, and my opponent has been a young, naive attorney. And now he's trying to ask a question, and it's phrased improperly. So I get up, I make an objection. "Judge, that's an improper question." The judge agrees with me. He says, "Objection sustained." Now the attorney tries to ask the question a different way. And guess what? It's still an improper question. Do I get up again? Well, in all likelihood, the judge may tell the attorney, "Listen, it's still improper. Ask it again." I might have to object a couple of times because that question might be so poorly worded, it might be confusing for the jury. Or it might be legally incorrect to ask that type of question. I'll give you a great example. An attorney can ask what's known as a compound question. "Mr. Jones, isn't it true you saw Dr. Gold on this date and he did the following things?" Well, if the patient says yes, is it yes that he saw the doctor on that date? or is it yes that he did the following things? That's known as a compound question, where you ask for more than one answer in one question. Ideally, if you're cross-examining a witness, you only want to ask one question, one fact at a time. Mr. Jones, isn't it true you saw my client, Dr. Gold, on this date? Yes. Isn't it true on that date you complained of the following things? Yes. Isn't it true that then he did a physical examination on you? Yes. So by doing that, you now ask leading questions that call for yes or no, rather than simply saying, hey, Mr. Jones, isn't it true that on this date Dr. Jones saw you, he did a physical examination, you complained of the following things? Well, you got to break it up, because now if he says yes, it's yes to what? To the first thing, the second part, the third part? You don't know. So that's called a compound question. And technically, it's not a good question. And it will confuse the jury, and anybody reading the transcript will be confused. What is he answering yes to? The first part, the second, the third? You don't know. So the better practice is ask one question per fact. Or I should say ask one fact per question. So that now when the witness gives the answer, you know exactly what the answer is to. So why do I share this information with you? I share it with you because this happens from time to time. And if you happen to be sitting in the courtroom either as an observer or as a litigant who has brought a lawsuit, don't be surprised if this happens to you here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.